Good evening. I'm Lauren Singer of Oasis of Peace UK. Welcome to the 12th Annual Rueff Lecture organised by the Lawyers Group. It is wonderful to see you all here and we're honoured to be joined by our guest speaker, Professor Philippe Sands QC. Just a couple of pieces of technical housekeeping before we move on. You will automatically be muted from our end, but you'll still be able to contact us by sending questions to the Q&A throughout the chat function, along with any technical concerns you may have. We also recommend that speaker view is kept on to maximise best viewing of this lecture. As you would expect, I would like to remind you that all views expressed by our speakers this evening are their views and do not necessarily reflect those of the Oasis of Peace UK or those involved with the charity. In a short while, you'll be seeing a video which we are showing with the kind permission of its producers, BBC World Service Witness History. I'm now very pleased to hand over to David Altaraz of the Lawyers Group, our chair for the evening. Thank you.
Good evening, everyone, and welcome to the 12th Philippe Rueff Memorial Lecture. My name, as Lauren has already said, is David Altaraz. I am the ex-chair of the Lawyers Group of the British Friends of Neve Shalom, Wahat El Salam, the Oasis of Peace. For those of you who are expecting our present chair, Harsha Shiwaram, to preside tonight, I should explain her absence and my presence. I am her understudy. Excuse me. I am standing in for her because she's unwell and has lost her voice. I gather that she is online and I wish her a speedy recovery from all of you. Now, it's a matter of some pride that this modest-sized charity has been able to attract such quality speakers over the years. From Israel, we've had Professor Michael Kariani, Attorney Gilead Sher, and Hassan Jabarin. From the United Kingdom, David Aronovich, Julia Newberger, Simon Sharma, and Bishop Rose Hudson Wilkin. I'm sure that some of you have heard all or some of those speakers. Tonight's speaker, Professor Philippe Sands, Queen's Counsel, continues that tradition. But before I formally introduce him, I must briefly touch on some other matters. First, I pay tribute to our generous sponsors, Mishkondareya. Our thanks to them. Next, Philippe Rueff, in whose memory this lecture is given. Philippe was a barrister, a successful criminal barrister, and a recorder of the Crown Court. He was also liberal in outlook, and when I say liberal, I mean liberal with a small L, not a member of the political party, although he may have been for all I know. He rightly saw Neve Shalom Wahat El Salam as a template for the future peaceful cooperation between the two communities in Israel. Many of us, myself included, share his vision. Our support for the village, and in particular the primary school and the School of Peace, is founded on the firm conviction that peace will only come to Israel through coexistence. We reject the extremists on both sides. We reject violence and we reject segregation. Philippe was the first chairman of the legal group of the British Friends of Neve Shalom Wahat El Salam, and it was he who recruited me onto his committee when we were both sitting as recorders in the Reading Crown Court. His untimely death in the autumn of 2009 robbed us of his invaluable counsel. He is still greatly missed. And all I can say is that these lectures, which have been continuing over the past 12 years, are a fitting tribute to his memory. Let me say something now about the village, the Oasis of Peace. About 40 kilometers to the west of Jerusalem, there lies a quite remarkable settlement, the village of Neve Shalom Wahat El Salam. Here you will find Israeli Arabs, and Israeli Jews living together in equal numbers. Here you will find a primary school where Arab and Jewish children from the village and the outlying community attend in equal numbers. And here you will find the School for Peace, which runs programs for Jews and Arabs aimed at promoting understanding between the two communities. Against the background of turmoil and strife in the Middle East, I sincerely believe that the village stands as a beacon of hope. Let me give you some up-to-date figures. There are at present some 70 families residing in the village. That figure will increase to 150 families once the planned expansion takes place. There is a long waiting list for those wishing to reside in the village, and that is a hopeful sign. In 2019, there were 268 children attending the nursery, the kindergarten, and the primary school. The majority of those children travel daily from about 20 communities within a radius of some 30 kilometers. The educational framework is bilingual and binational, bilingual in Hebrew and Arabic, with about the same number of Arab and Jewish children in the system. Since the School of Peace first opened its doors in 1979, over 70,000 Jews and Arabs have attended its programs. I am now going to ask for there to be shown a short video, the work of the BBC World Service, Witness History. Thank you, Mark.
This is a remarkable picture. Tom and Feder are two 10-year-olds who share a desk at school. They're friends. What's remarkable about it is that Feder is an Arab, Tom a Jew. They're the product of a place called Neve Shalom. It's Hebrew for Oasis of Peace.
The community was formed by 4 families, 1 Palestinian family and 3 Israeli Jewish families. We wanted to try to live in an alternative way, Jews and Palestinians together in equality in one piece of land. I'm Dr. Nava Sonnenschein. I'm an Israeli Jew, and I came to live in Wahat Salam, Neve Shalom in 79.
I am Daoud Boulos. I'm a Palestinian Arab. I'm a resident of Wahat Salam, Neve Shalom.
It was a very small, tiny community with no trees, no running water, no connection to electricity, but we had big dreams.
Here we found hope, and we wanted to start a life with people who are enlightened, who are, accept us as we are. When we came, of course, there were some questions about, are you fooling yourself? Are you going to be in some kind of utopian society where it's not really realistic? And I said, maybe, but, we hope it's going to teach others that it's actually possible, because this is why we are here.
Although only 15 families live at Neve Shalom, 7,000 teenagers have passed through attending its peace workshops. Some had never met a member of the opposite community until they came here.
It's very powerful to see a moment of change. Really, people realize that what they thought before, it's not the reality. And we learned a lot. This is how we started the School for Peace.
The different, events that took place outside the village, like the Intifada, the war in Gaza, initiated a lot of talk and discussions and debates. My youngest daughter, for instance, her opinion on the issue of army service, for the Jewish Israelis, because here it's compulsory service. You can't say no, really. She said that, I expect all the people who come to be part of this community, part of this project here, Wahat Salam Neve Shalom, not to serve in the army. But I know this is something, these are easy words to say on our part. And I know it's extremely difficult for the other side.
Yeah, my three kids went to the army, but not to be combat soldier because they didn't want to fight to be soldiers. Now, when I see the children playing together, laughing together, quarreling together, it feels good.
The majority of the kids that are studying here, they're not Wahat al-Salam Nabay Shalom kids. They're from outside. You know, the parents want them to have our kind of education, this exposure to the other side in an early age. And it shows the effectiveness of this community.
It's a working model of almost 40 years that we are here, and it can work.
Ladies and gentlemen, I hope the sound was rather better than it was at my end. But thank God there were some subtitles so that you were able to follow what was being said. I must now introduce our speaker, Philippe Sands, although in truth, he needs no introduction. He is a leading international law and human rights silk. He is a highly respected academic, being a professor of laws at University College London. He serves on a panel of arbitrators at the International Centre for the Settlement of Investment Disputes and the Court of Arbitration for Sport. He is a broadcaster on radio and television, whose documentaries include My Nazi Legacy, The Rat Line. I have to say that was a series to which I was frankly addicted week after week. It was fantastic. And his current offering, The Nuremberg Legacy. He is a prolific author whose recent works include East-West Street on the origins of crimes against humanity and genocide, and The Rat Line, the book from the radio series, Love, Lies and Justice on the Trail of a Nazi Fugitive. Both books I have read, as I'm sure many of you have. They are, in my judgment, quite exceptional. The high regard with which Philippe is held is reflected by the unusually large numbers of people attending tonight's lecture, the largest, as far as I'm aware, in the history of this charity. The subject of his lecture is thinking about an international rule of law, and with any luck, he should now take my place on your screen.
Thank you, David, and thank you to Oasis of Peace and all who run it. What an amazing project, and what an amazingly inspiring exercise at a time of such difficulty. I'm very honoured and very privileged to be invited to give this Philippe Rueff Memorial Lecture. I think what you do as an organisation is astonishing. And at its heart, of course, is the idea of living in a world in which the rule of law prevails and can be given effect. You were very generous, David, in introducing me, and I think those who are listening attentively will have seen that really what runs through all of my various activities is a very strong commitment to the idea of the rule of law at the international level. That's my domain. I work at university, I teach international law, I practice before international courts and tribunals, I write about international type issues. And the beating heart of what I do is the rule of law and examine what is happening to it and how we protect it at the international level in this most difficult time. And I thought what I'd do, I've got about 35 minutes, and I think we can then throw it open to some conversation and some questions, was just muse a little on this theme. How do we think about the rule of law at the international level? One thing I'd say at the outset is we must recognize that the rule of law at the international level, as we currently know it, is a very recent creature of our human inventiveness. I mean, modern international law really only begins as recently as 1945 with the creation of the United Nations Charter. And I say modern because I'm thinking of two aspects. Firstly, a move away from the system that existed before, which recognized only states as international actors. And secondly, the creation of new mechanisms for applying international rules at the domestic level, in national institutions, but also at the international level. And you can trace the origins to the modern international rule of law to an extraordinary moment in 1941, in August, off the coast of Newfoundland, when American President Franklin Delano Roosevelt and British Prime Minister Winston Churchill met off the coast of Newfoundland on board an American boat and signed a piece of paper, literally a single sheet. You can look it up and Google it. It's a remarkable document. It's called the Atlantic Charter. And the Atlantic Charter, drafted before the United States entered the war, but it's likely to be happening, really sets out embryonically our modern system of international rules. It proposes three fundamental foundations: ban on war in international relations, secondly, the development of greater international trade and economic interrelations, and thirdly, rights for individuals and groups of individuals. And that architecture, three pillars, would operate under a multilateral framework, move away from bilateral arrangements to a global system, which would be taken forward in international relations. And it was the basis for the creation of the United Nations 4 years later in 1945. And in the 5 years that followed, the modern architecture of rules that was created. Before then, individuals, groups had no rights under international law. Individuals, groups had no access to international institutions under international law. It was an incredibly revolutionary moment. And that was 75 years ago. And there have been a huge number of developments that I don't have time to talk about now, although I'm going to come back to talk about a few examples, tell you a little bit about how it works. But the simple point I want to make at the outset is that the modern framework is relatively recent, and it is a fragile creature. And we must therefore have limited expectations about what it can deliver. That doesn't mean we give up on it. It doesn't mean we don't get extremely irritated or angry when it doesn't deliver, which is quite often, especially nowadays. But put it in its context. Before 1945, countries could, with absolute impunity, treat their citizens as they wished. There were no international rules placing limits on what they could and could not do to their own people, to their own human beings. That was transformed after 1945. And it is, if I can put it in that way, when I'm often asked about the way forward, the idea of the international rule of law is a long game. It's not that you're going to have thousands of millennia of human interaction, and then suddenly in 1945 along come a few leaders and a few countries to agree a new framework, and everything magically works. So we have to be, to a certain extent, patient, and we have to nurture this creature that we have. In the intervening years, over 75 years, of course, a great deal has happened and the world has changed in many ways. You're seeing that. Many of you will be watching and reading in your papers and on the internet what is about to start in Glasgow, the idea of all the countries of the world coming together to reach agreement on emissions into the atmosphere of carbon dioxide to protect us from climate change, what I think we more properly ought to be called global heating. And that would have been unimaginable 100 years ago, to bring essentially the entire planet together to agree binding international rules on what we can and cannot do, rules which will affect each and every one of us. It will change the boilers in our homes, it will change the cars we drive, it will change the way we travel, it will change the way we eat. We're all becoming acutely conscious of this extraordinary change that is taking place. And it's taking place basically because we have an international rule of law. We have things called treaties, and we have things called institutions, and we things called courts and tribunals. And we are concerned, of course, that the international arrangements are not as strong and effective as they might be. But again, that's because they are relatively new. We're struggling to find a way forward. Given what your work is, I wanted to focus really on three cases that allow us to explore a little bit what the international rule of law is. And they all relate to the Israel-Palestine situation. And they are all developments that have occurred because of this system of rules that was put in place in 1945. The whole structure of the interweaving differences and disputes that arise is, of course, premised on the creation of a new state, Israel, after the Second World War, which was done through the United Nations, which I just mentioned, effectively created and recognized by an act of that international organization. And the totality of the issues that we now face can all be seen through the lens of a legal framework. Of course, it's not the only framework. There is also politics, diplomacy, culture, geography, ecological aspects, and so on and so forth. But the law gives us a lens to explore what is happening, whether there is progress, whether there is not progress. Now, some of you will be aware of a decision given by the International Court of Justice in 2004, an advisory opinion from the International Court of Justice given on the basis of a request from the General Assembly of the United Nations. And the question that was set by the General Assembly to the International Court of Justice was, what are the legal consequences arising from the construction of the wall being built by Israel, the occupying power, in the occupied Palestinian territory, including in and around East Jerusalem, as described in a report then issued by the Secretary General back in the early 2000s, in considering, and this is the key point, the rules and principles of international law, including the Fourth Geneva Convention of 1949 and relevant Security Council and General Assembly resolutions. So the entire question, the entire exercise is premised on the idea that we have things called rules that are out there, and those rules need to be applied and respected. Now, pause for a moment. What is an advisory opinion of the International Court of Justice? The court has the competence to deal with two types of situation. It can deal with disputes between two or more countries. Those are called contentious cases. But Israel has not accepted the contentious jurisdiction of the International Court of Justice. And in 2004, at least, Palestine was not considered a state which could bring a case against Israel, or indeed against anyone else, before the International Court of Justice. It didn't have access to it. So the problem was circumvented, if you like, by a decision of the General Assembly, a majority of the members voting to send a legal question to the International Court of Justice. And the advisory opinion of the court is not binding as such on states, but it is binding on the body that made the request. The UN General Assembly has an obligation to give effect to the advisory opinion given by the court. So what did the court say in its advisory opinion? The answer that the court gives, of course, is dispositive up to a point. The court said that the settlements that had been established, some of the occupied territories, were established in breach of international law. The court concluded that the construction of the wall along with the measures taken previously, impeded the exercise by the Palestinian people of rights of self-determination, and that self-determination existed under international law. The court concluded that the construction of the wall and its associated regime were contrary to various provisions of international law, including the Geneva Conventions of 1949, because they impeded the liberty of movement of various people. The court concluded that the construction of the wall tended to alter the demographic composition of the occupied Palestinian territory, and it thereby contravened the Fourth Geneva Convention. The court concluded significantly, as a fifth point, that those obligations were not overridden by security objectives or any right of self-defense. In other words, you can't trump the rights of individuals to move and so on and so forth by a generalized notion of self-defense or national security or a so-called claim of necessity. Sixth, Israel was called upon by the court to put to an immediate end, its violation of its international obligations by ceasing all works on the construction of the wall. Seventh, that Israel must make reparation for damage suffered by natural legal persons. And eighth, all states are under an obligation not to recognize the illegal situation resulting from the construction of the wall. So the reaction to that advisory opinion was largely as you might expect. Israel and the United States, amongst other countries, but only a small number, said that they were not bound by it and they would not give effect to it. Does that mean that the decision, the advisory opinion of the International Court of Justice, is entirely without effect? It does not mean that. It has political consequences because it allows both Israel and Palestine to know what the nature and extent of their rights are, and that has implications for the legal direction and the political direction that will be taken in the future, including the possibility of a political settlement. You will all say, but look at what has happened. The United States has now acted to put its embassy in a place that it shouldn't put it, and that is absolutely correct as a challenge, and it certainly undermines the advisory opinion. On the other hand, other bodies have adopted a different approach, and I want to draw your attention to a case that I'm sure most of you have never heard of, which is a recent judgment, 2019, of the Court of Justice of the European Union. The case is called Organisation Juive Européenne and Vignoble Psagot Limited against the Ministre de l'Économie et des Finances. And the decision is significant because the situation faced by the Court of Justice of the European Union was one which concerned the labelling of products made in territories occupied by Israel. And what the European Court of Justice ruled is that foodstuffs that originate in a territory occupied by the State of Israel must bear not only the indication of the territory, but also where those foodstuffs come from, a locality or a group of localities constituting an Israeli settlement within that territory, the indication of that provenance. In other words, under European Union law, states are required to show that if you go to your local supermarket and you buy a product that says produced in Israel, avocado, grapefruit, whatever it may be, if it comes from the occupied territories, it must display that fact on the label that indicates its origin. How did the court get to that position? The court got to that position on the basis, in very large part, of the advisory opinion of 2004. The court determined at paragraph 48 of its judgment that the settlements established in some of the territories occupied by the State of Israel are characterized by the fact that they give concrete expression to a population of policy transfer conducted by that state outside its territory in violation of the rules of general international humanitarian law. And it cites the advisory opinion of the International Court of Justice. Moreover, that policy has been repeatedly condemned by the United Nations Security Council and by the European Union itself. The European Union is to contribute to the strict observance of international law, including the principles of the United Nations Charter. So it is often said, including in my presence, that the advisory opinion is completely useless. It has had no effect whatsoever. It has not stopped Israel from doing X, Y, or Z. It has not stopped Palestine from doing X, Y, Z. No, that is not correct. There are numerous examples to show how the advisory opinion in the law of domestic courts has changed the practice. It is not perfect in its effect. It is not even in its effect. It has not stopped the illegality in its tracks, but it has been transformative. Just to pause for a moment here, in another context, which many of you may not have heard about, a place called Chagos, which the British government calls the British Indian Ocean Territory, the same thing has now happened in relation to an advisory opinion given by the International Court of Justice in 2019, which determined that the United Kingdom right now is an illegal occupier of the territory of Chagos because it was wrongly separated from Mauritius in 1965 in violation of international law, because the separation of a part of the colony of Mauritius in 1965 was not consented to by the population of Mauritius, and the principle of territorial integrity under international law and the right of self-determination of a country had not been respected. So the United Kingdom too now finds itself on the receiving end of an advisory opinion of the International Court of Justice. And just like Israel, the United Kingdom has said we're not bound by this advisory opinion, we're not going to give effect to it, and no, we're not going to allow the people, the 2,000 people who were removed between 1968 and 1973 in blatant violation of international law to return. What is to be done? Well, again, you know, when a country like the United Kingdom, supported on this occasion by the United States, says we're not going to honour the advisory opinion, it's very difficult for a small country like Mauritius to turn around and force them out. So what Mauritius has to do is go to other measures. Now, what this advisory opinion did, very wisely, is it said every specialized agency of the United Nations must give effect to this decision of the International Court of Justice. And as a consequence, the United Nations has now changed its flag to show that Chagos belongs to Mauritius, is part of Mauritius, not part of the United Kingdom. And the specialized agencies have bit by bit, even in the last 2 years, acted to prevent the United Kingdom from exercising its sovereignty. The Food and Agriculture Organization of the United Nations has determined the United Kingdom cannot exercise fishing or in the waters around Chagos as a coastal state because it's not the coastal state. The Universal Postal Union just a few weeks ago has determined that stamps issued by the so-called British Indian Ocean Territory will no longer be recognized internationally. Put a stamp from BIOT, as it's called, on your envelope, and it will not go beyond the post office in which it has been dispatched. It will not reach its recipient. That is a direct practical consequence. The International Tribunal for the Law of the Sea in Hamburg has determined that the advisory opinion of the International Court of Justice has determinative legal effects, that Mauritius is the coastal state, and it is for Mauritius, not the United Kingdom, to negotiate a maritime boundary with its nearest neighbour, which is the Maldives. Again, the consequence of the advisory opinion is not to immediately change the political situation, but bit by bit, it has consequences. It's part of the slow construction of the idea of an international rule of law. What I'm trying to say at this point is it's not right to simply put one's hands up in the air and say that the developments of these international rules and norms the developments of decisions of international courts are all useless, they have no effect, they don't change anything. That is not how it works. They're not perfect, they do not have instant transformative effects, that is correct, but they have some effects, and bit by bit they change the framework or can contribute to a change of the framework. So that's the context for me to come to what is the main thing that I want to address when we're thinking about the rule of law, and that's to help you perhaps understand some of the complexities of a decision that many of you will know about, but you may not have gone to read the actual decision, and that is the recent ruling of the International Criminal Court in The Hague in relation to a complaint made by the Palestinian Authority that the Israeli Defense Forces have been violating international criminal law by certain actions on the territory of Palestine. I want to help you begin to understand how one puts this in the broader framework of the international rule of law and what exactly has been decided as we incrementally construct a way forward to extricate ourselves from a dire political situation, using to the best extent we can the idea of an international rule of law. The International Criminal Court was created in 1998 at a negotiation that was conducted in Rome. It is created by a treaty, which is called the Statute, and currently 123 countries in the world are parties to the Statute. The United Kingdom is a party, the United States is not, Israel is not, China is not, Russia is not. There are about 70 countries in the world that are not parties to the Statute. And the way international law works, if you're not a party to the Statute, you are not subject to the jurisdiction of the court or the rulings and operation of the court. You can't have a judge, you can't participate in the choice of the prosecutor, you can't engage in those activities. But does that mean that nevertheless the court cannot have some powers in relation to countries that are not parties to the Statute of the International Criminal Court? Again, a little bit of history here. One of the other things that happened in 1945, which was enormously significant, was the creation of the modern system of international criminal law. It was through something called the Statute that created the International Military Tribunal that sat in Nuremberg, the famous Nuremberg Tribunal. You've all seen the images, you have heard of it, you've seen the impressions of the 24 Nazi defendants sitting in the dock, you've seen the prosecutor, you're probably familiar with Robert Jackson's opening speech, never again, an aspiration that of course wasn't quite met. But this was a hugely significant moment because this was the first time in human history that individuals associated with the leadership of a country found themselves in the dock before an international tribunal. It had never happened before. And, second point, the Nuremberg Statute created, in effect, new rules of international criminal law. The crime of aggression, waging illegal war, crimes against humanity, harm to individuals, and of course the crime of genocide invented by Raphael Lemkin, the destruction of groups. Crimes against humanity and genocide, the subject really of my book, East-West Street. Nuremberg gave its judgment exactly 75 years ago, on the 1st of October 1946. And so actually there have been quite a few markings of that moment. And bit by bit, very slowly, incrementally, the idea of international criminal justice has moved forward. For 50 years, countries tried to negotiate a statute to create a permanent international criminal court, and they didn't succeed until 1998. So the rule of law and international justice is not a speedy thing. It's a long game. But in 1998, finally states agreed on the creation of an international criminal court, and it came into being in 2002, and it sits in The Hague, and it has jurisdiction over 4 crimes. War crimes, which is a 19th century invention, doing nasty things to people in the context of war and armed conflict. And then the three crimes invented in 1945: aggression, crimes against humanity, and genocide. And as I said, in 2002, the International Criminal Court started to function and started to operate. Then in 2015, Palestine joined the International Criminal Court. And interestingly, when the state of Palestine, as it called itself, ratified the ICC statute, only one country objected, and that was Canada. No one else objected. This was a singularly important moment, although the consequence of that is perhaps not as far-reaching as some may think. But in 2015, Palestine joined the statute of the International Criminal Court and immediately referred certain matters concerning interventions by Israel on its territory to the prosecutor of the International Criminal Court. In 2019, the prosecutor of the International Criminal Court completed her preliminary investigation to see if there was arguably a case to answer. But she faced a number of what are called jurisdictional objections. Israel said, you can't exercise jurisdiction over us or over our armed forces. And bear in mind, the International Criminal Court does not have jurisdiction over states or companies. It only has jurisdiction over individuals, because only individuals commit crimes under international law. And because Israel argued that the court did not have jurisdiction over actions by its individual members of its defense forces, the prosecutor referred to a panel of 3 judges a number of jurisdictional questions. And on the 5th of February this year, the court's 3 judges delivered an answer. So what were the jurisdictional questions that were raised? The first question is whether Palestine is to be treated as a state within the meaning of the statute of the International Criminal Court. Secondly, what is the delimitation of the territory of Palestine for the purpose of defining the court's territorial jurisdiction? And thirdly, do the Oslo Accords have any implications for the determination of what is the territory of Palestine? Now you can see immediately that these are potentially explosive questions, and one has to feel for the 3 judges who are faced with these enormous political issues, but are only going to decide them by reference to the law. Their task is to interpret and apply the statute of the International Criminal Court, which is a treaty. And they proceed to do exactly that. What do they conclude? On question 1, the judges conclude that Palestine is a state party to the statute. Now, let me just pause for a moment here. The decision was unanimous, and the judges went out of their way to draw the distinction between recognizing an entity as a state party to the statute and recognizing the entity as a state under general international law. So it's not correct to say that the ruling confirms that Palestine is a state under international law, but what they have decided is that Palestine has the capacity to ratify the statute of the International Criminal Court, and its ratification is legally effective. That is a huge conclusion. It didn't go quite as far as the Palestinian Authority wanted, and it went much further than Israel and the United States would have liked. And you will recall what the consequence of the decision was. The consequence of the decision was that the administration of Mr. Trump in the United States was to impose sanctions on individuals associated with the International Criminal Court, including judges and the prosecutor personally. Now, when that happened, I have to say, I thought back to 1945 and how the world had changed. It was the United States that created the idea of an international military tribunal for Nuremberg. It was the United States that led the prosecution, famous arguments made by US Supreme Court Justice Robert Jackson on leave. And now, 74 years later, the United States is imposing sanctions, travel and financial, on the prosecutor of an international criminal court and on judges who've done nothing more than exercise their judicial function in interpreting and applying the law and making certain findings. So we can come back perhaps in questions and ask us what this means in terms of the state of the world. But the decision is potentially very, very significant. Secondly, the three-panel pretrial chamber decided by a majority that as a consequence of its first finding that Palestine is a state party to the statute, Palestine qualifies as the state on the territory of which the conduct in question occurred for the purposes of Article 12 of the statute. And what does that mean? What that means is that under the rules of the statute, any international crime which is alleged to have been committed on the territory of a state party falls within the jurisdiction of the court. And it doesn't matter who commits that crime, allegedly. In other words, the ICC has jurisdiction in relation to the territory of all 123 state parties and in relation to nationals of all 123 state parties. Let me put it another way. If an American commits the crime of genocide on the territory of the United Kingdom, the fact that the crime is alleged to have been committed by a national of a country that is not a party to the statute is completely irrelevant. The fact is that the legal provisions make clear that it is the territory of the state party that matters. And that's why, for example, since 2002, the International Criminal Court has had jurisdiction in relation to British and American nationals alleged to have committed crimes on the territory of Afghanistan, because unbelievably, Afghanistan has been a party to the statute of the International Criminal Court since 2002. And that is why, going forward, unless Afghanistan withdraws its ratification, the International Criminal Court will have jurisdiction over crimes allegedly committed by the Taliban in the period that has already passed and in the period going forward. The consequence of the court's second ruling of the three judges is that if there is an allegation that an Israeli national has committed a crime that falls within the jurisdiction of the International Criminal Court on the territory of Palestine, the court has jurisdiction to examine the commission of that crime. And the third ruling by the International Criminal Court, again by a majority with one judge dissenting, is that the court's territorial jurisdiction in the situation in Palestine extends to the territories occupied by Israel since 1967, namely Gaza and the West Bank, including East Jerusalem. That ruling, of course, brings many potential actions within the jurisdiction of the International Criminal Court. Pause for a moment. The prosecutor has been very careful in identifying the crimes that she is interested in as operating, if you like, on both sides of the divide. So just as with Oasis of Peace, we have residents who are Arabs and residents who are Jews, the prosecutor has determined she will investigate not only the crimes that are alleged to have been perpetrated by Israeli forces or individuals associated with Israeli forces on the territory of Palestine, but the use of Palestinian territory for example, firing rockets into the territory of Israel. That too falls within the jurisdiction of the International Criminal Court. Now, the prosecutor who made the request has now, her term of office has come to an end, and a new prosecutor has taken office in June of this year, and that happens to be a British national, Karim Khan QC. And into Karim Khan QC's inbox falls the, shall we say, delicate task of determining now which crimes precisely to investigate. And I will say no more than watch this space in terms of what happens next. But again, to come back to where I started, a lot of people will say, oh, it's all useless. All these rules are useless. They're not applied. All these courts are useless because they don't do anything. All these judges are useless. No, it isn't as simple as that. Again, I say it's not perfect. It's relatively little in the bigger scheme of things, but it is not without great significance. It has a huge impact. Let me give you an anecdote in relation to that kind of impact, politically and diplomatically. 2 years ago, I was involved, I still am involved, in a case brought by a small African country called the Gambia against Myanmar in relation to the treatment of the Rohingya community, a Muslim community which has been terribly mistreated by the dominant powers in Myanmar. And the Gambia brought a case to the International Court of Justice, a different court from the International Criminal Court, a court that only deals with interstate cases, for a determination that Myanmar had violated the 1948 Convention on the Prevention and Punishment of Genocide, the Genocide Convention. In other words, that Myanmar was perpetrating a genocide against the Rohingya community. And the hearing was set for December 2019 in a phase called provisional measures, a sort of injunctive relief, where the Gambia asked the court in The Hague, the International Court of Justice, to adopt a ruling that Myanmar must cease with immediate effect its genocidal policies and acts in relation to the Rohingya community in Myanmar. A month before the hearing began, I found myself in Washington doing an academic conference at George Washington University. And I was on a panel with a very dear friend of mine, a man called Thomas Bergenthal, who had been born in Poland in the 1930s and who in 1944 found himself as a resident of the concentration camp at Auschwitz, the extermination camp at Auschwitz. And he was one of the children who was in the care of one Joseph Mengele, the famous doctor. Now, happily, Tom Bergenthal survived, and he went on to have a very distinguished career as an academic and as the American judge at the International Court of Justice. Indeed, I have to say, and I've talked about this with him at length, he was one of the dissenters in the advisory opinion on the legal consequences of the war, parts of that decision, on jurisdictional grounds, not on the merits. And Tom said to me at the academic seminar in Washington, can you imagine, if you go back to 1944, what it would have meant for people like me, children, to have had an international convention like the Convention on the Prevention and Punishment of Genocide, and to have had an international court, and to have had a faraway small country go to that international court and say to the court, tell Germany you can't treat human beings in this way. He said, you know, maybe it wouldn't have stopped it, but it would have given us hope. It would have changed the political dynamics. It would have had some sort of an impact also on what happened and what followed. We don't know what it is, that's a matter of speculation, but it might have made a difference. And that anecdote, again, is one of the reasons why I, despite my rather realistic view of the world, which is in a very bad place right now in terms of matters of nationalism and xenophobia and populism, nevertheless is not in the same place as it was in 1944. There has been a change. There is a difference. It's not perfect. It has too limited a consequence, but it is a lot better than nothing. And that, I think, is a very significant development. I have to say, I've been asked this a lot. I'm not involved in the current case of the International Criminal Court, but I've studied the rulings very carefully, and I think they're perfectly plausible and reasonable. I think that the decision has very significant implications in a political context going forward, and I absolutely rebut the suggestion that has been made by some associated with the government of Israel that this is anti-Semitism at work. It is not. I know these judges. They are doing nothing more than their very difficult task of taking the facts and applying the law as they interpret it to those facts. That is not an easy exercise, and they are entitled not to be attacked by politicians and others for simply doing their job. And in particular, they are entitled to expect treatment other than the imposition of sanctions on them for simply having acted as international judges. So to conclude, maybe we can follow with questions. International justice is a very long game. It's one step forward, one step sideways, another step forward, and one step back. The alliance of countries that support the development of the idea of an international rule of law shifts, it changes, it evolves. At any one time, one country may take one direction, another country may take another direction. On the matter of Chagos, which the United Kingdom is not abiding by its international obligations, that fact undermines greatly the attacks by the United Kingdom and the United States, for example, on China, for not abiding by a law of the sea ruling in a case 5 years ago brought by the Philippines. I happen to have been counsel for the Philippines, so I'm well aware of China's violations, but I'm deeply troubled by the move away from a commitment to the international rule of law by the current government in the United Kingdom. And of course, it's not just in relation to Chagos. How ironic that the country that gave us the United Nations Charter and the idea of an international rule of law now has a government which feels that it can, with impunity, tear up the protocol on Northern Ireland in relation to the Brexit withdrawal agreement. Whatever you think about Brexit, whatever you think about the withdrawal agreement, whatever you think about Northern Ireland, there is in force a binding international treaty. And that binding international treaty determines the rights and obligations of both sides. On one side, the United Kingdom, on the other side, the European Union. And neither side has the power under international law and the principle of pacta sunt servanda, a treaty is binding, to simply say, oh, we're walking away from this agreement. The agreement has mechanisms for resolving disputes. The agreement has mechanisms for the period of application of the agreement and what happens if one country wants to leave the agreement. But when you sign an international treaty, you submit yourself to the rule of law. And the legislation that was put before the British Parliament in the last few months, which simply says we're going to ignore the Northern Ireland Protocol because it would only be a temporary and limited violation of international law, is a scandalous first. No British government has done this before. British governments have broken international law, but they haven't done so knowingly with their eyes open and with a comprehensive embrace. And that's why it makes today's development, which you are probably reading about in your newspapers or online or whatever, all of a sudden, the United Kingdom is very upset with the French because the French have arrested a boat that was fishing near Le Havre, apparently without a license. And the United Kingdom is now saying that's in breach of international law. You can't do that. This is going to lead to a trade dispute and so on and so forth. A country that has not got its own house in order on the rule of law is not best placed to criticize the actions of another country on the basis of an alleged so-called violation of international law. I don't know enough about this fishing issue to know the rights and the wrongs or the legalities. It's just that I don't have a great deal of confidence in a British government pointing the finger of lawlessness at other countries at a moment where it too is engaged in what might now be called serial lawlessness at the international level, certainly in relation to Chagos, also potentially in relation to the Northern Ireland Protocol to the Brexit withdrawal agreement. So to bring to a close, before we throw it open for conversation, the world is very different from what it was in 1945. We have a rule of law at the international level. It is not perfect, but it is a big change on what we had before 1945. It is a fragile construct. There are plenty of countries that would like to rip up the system and move back to the good old days of power politics, might is right, sending military vessels halfway around the world and beyond. But I don't think that is going to happen. The history of international law is the history of building things up, an act of implosion, followed by a rebuilding, always based on what came before. We will not be able to get rid of the idea of the rule of law in international relations. We will not be able to get rid of the idea of rights for individuals and groups. We will not be able to get rid of the idea of an international criminal justice system, and so on and so forth. How it operates in the coming years is another matter completely. So although I'm slightly pessimistic about the state of the world right now, if one takes a long narrative, I remain a deeply optimistic person. And I sort of take my cue from one person in particular. When I was a very young academic in my mid-20s, I was a research fellow up at Cambridge University. And I had the great happiness of sharing college lunches with a very distinguished professor of English legal history, Sir John Baker. And once a month, he would invite me to have lunch with him. And he wanted to know, he's a curious and interesting man, what I was working on. And I would tell him what I was working on. I'd say, some aspect of international law. And John Baker would say, yes, Philippe, yes. We had a similar problem in English law. And then he'd pause and he'd say, I think it was must have been about 1472. And it took 275 years to sort it out. And that's the context in which you have to think about the international rule of law. It's not useless. It's not fantastic. It's here to stay. We need to nourish it. We need to look after it. We need to take care of it. And we need to build it up and not put it down. Won't produce immediate results in many cases, Chagos, Palestine, Israel, but it's a far better thing than the alternative. Let me stop there. I'm very happy, David, now to put it over to questions or conversation if there is any such desire.
I'm not sure we can have conversations because we're not using the hands. But if anyone wants to put any questions to Philippe, please put them in the chat box with your name if you want to acknowledge your authorship, and I will read them out to Philippe and ask him to answer them. One thing did strike me, Philippe, as you were delivering your lecture, was that Brenda Hale would have felt some sympathy with the judges of the International Criminal Court who were being attacked by Israeli politicians.
I mean, absolutely. I mean, Brenda Hale would have, and so would the 3 Court of Appeal judges. Do you remember that
Yes, indeed.
example? A little before Brenda Hale and the Supreme Court dealt with certain issues, that there was a question about the meaning and effect of Article 50 and the obligations of the United Kingdom and putting certain things to Parliament or not. And you remember the headlines. I've never seen headlines like them before in the Daily Mail, in the Daily Express, and in the Daily Telegraph, coordinated, in my view, by number 10 Downing Street, with the headlines, "Enemies of the People." And that was used in relation to 3 distinguished Court of Appeal judges who, like the ICC judges, found themselves in the enormously complex situation of having a case put before them and being required to identify the facts, identify the law, apply the law to the facts, and reach a conclusion. Attacking judges in this way is absolutely disgraceful. One of the things the rule of law requires, and if you want to get a primary basic reader, I can recommend nothing better than Tom Bingham's little book published by Penguin, The Rule of Law. One of the things the rule of law requires is treating judges with respect. You don't sanction them. You don't accuse them of being enemies of the people. You don't abuse them in the newspapers. And that development in, I think it was 2019, was an absolutely shameful moment in English legal history. No one I know was aware of it having happened before, and it marked a new direction. If you're not going to safeguard the rule of law domestically, you're not going to be able to promote a rule of law internationally. And I think that when we see these things happen, irrespective of our political views, it doesn't matter what they are, we must speak out, we write to our MPs, and we tell them that this is totally unacceptable. The rule of law requires respect for our judiciary.
Yes, we could probably continue this conversation for a long time, Philippe, but I must now turn to put some of the questions to you. The first one is submitted by Sir Andrew Burns, and he asks, what are the lessons from the Holocaust that we can all usefully apply in real time to forestall further genocidal activities in the 21st century, especially in countries unaffected by the Holocaust?
Well, a fantastic question. I mean, it's obviously one that I've thought a lot about, having read East-West Street, having written East-West Street, well, I've read it too, and The Rat Line. I'm really asking myself, what are the big takeaways from this? And I think the big takeaway, and this comes in well, I mean, there are a number of takeaways. Let me just give 2. One is that individuals can really make a difference. I think a lot about Hersch Lauterpacht and Raphael Lemkin with their twin inventions of crimes against humanity and genocide, which didn't exist before they put them on paper and proposed them as ideas with a legal content. It was incredibly moving. Last week I went to the opening of the new Second World War and Holocaust galleries at the Imperial War Museum. I don't know if any of you have been, but the end of the Holocaust bit of it is a sort of exhibition about Lemkin and Lauterpacht. Out of the darkness came these extraordinary inventions, and I found that just incredibly uplifting. And what that tells me is that in the darkest and most difficult moments, try not to curl up in a corner and weep. Instead, be inspired by people like Lauterpacht and Lemkin, who decided to put pen to paper, create ideas, energetically lobby, persuade governments to do things. And that, I think, is a very important lesson that I take. The second one, which is probably more in relation to the kind of thing Andrew is thinking about, is what is to be done when we see things happening that we do not like. And one of the things that I've drawn from the research on The Rat Line, which is a book that is based on 10,000 pages of letters and diaries of a top Nazi couple, and I mean a top Nazi couple. I wrote it because I was fascinated to understand about the private lives of this couple, Charlotte and Otto Wächter, to be able to understand what makes highly intelligent, highly cultured, highly educated human beings do monstrous things. It's one of the great mysteries of life. How could these people have done it? And reading their letters and their diaries, you begin to understand. And one of the things that emerges from their private lives is that these horrors always begin with relatively little things. And if you cross a line and get away with it, you will think to yourself, I got away with it. I might as well go to the next level. And you cross another line. And of course, Primo Levi and Raphael Lemkin both put it in the same way. One thing always leads to another. And if you let people get away with things, if you don't call out misbehavior when it first happens, however innocuous it may seem, you're in a very dangerous and difficult situation. And that's why I think right now, in any country, but I'll speak only about our own, which I know best, if we see or hear things that we think cross a line, we must call it out. It is referred to sometimes as othering. One of the questions I'm often asked is, what are my lessons from dealing with all these horror cases I do all over the world? And I have seen an awful lot of horrors and an awful lot of mass graves. What's the common theme? The common theme is it always begins with othering, basically identifying a group of people you don't like and saying they've got to be treated differently. They are undermining us, they are attacking us, they are harming us. We must act against them. That's always how it begins. Sometimes it begins with ridicule, sometimes it begins with humiliation, sometimes it begins with relatively minor abuses, but it always escalates. And so when we see that kind of behavior, I think we have to call it out, whoever is engaged in it, whether it is a prime minister or a politician or a leader of the opposition or whoever it may be. We have to call it out, and we have to respond, and respond vociferously, write about it, talk about it, agitate about it. The depiction of human beings in negative ways simply because they happen to be a member of a group you do not like is not a good thing. And that is how it begins. That is my big takeout. And I think about it a lot because I've done a deep dive into this curious today Ukrainian city called Lviv. It used to be Lvov when it was in Poland, Lemberg when it was part of the Austro-Hungarian Empire. And I often think about the folks who were living there in the 1920s. You know, Oasis of Peace is dealing with two communities trying to live together. In fact, it's more complicated than that. We all know that. In Lemberg or Lvov in the 1920s, there were three communities: the Ruthenians, today known as Ukrainians, the Poles and the Jews struggling to coexist. If you had asked any of those communities in the mid-1920s, could you imagine a situation in which two of the three communities would be gone within 20 years? The Jews because they'd been exterminated, the Poles because they'd been banished. People would have said it's impossible. It could not happen. And walking around London, a city I love deeply, with all its diversities, I ask myself the question, could it not happen here? Of course it could happen here. It can happen anywhere. We have to be alert, and we have to call things out as soon as we hear them or see them. And we have to be courageous about that. One of the people I've come to know, curiously enough, and he is a deep friend now, is the son of Hans Frank. Hans Frank was Adolf Hitler's lawyer, governor of Polish-occupied Poland, and the man who exterminated 4 million human beings and was hanged at Nuremberg for it, 3 million Jews and 1 million Poles, including the families of Lauterpacht and Lemkin, and the entire family of my grandfather, who remained in Lemberg after my grandfather left. But he produced a son, who is a wonderful man called Nicholas Frank. And I've often done events with Nicholas, who is a very strong and principled person, who is often asked what is to be done. And he says two words: civil courage. And what does he mean by civil courage? What he means is stand up and object when you see things you do not like. And Nick, I think, has got it absolutely right. We have to be civilly courageous and willing to stand up and object, even if we are alone or in a minority, and say that is not right. You cannot treat people like that. You cannot talk about people like that. And particularly if it's in our own back garden, that is the most important place of all. It always starts locally.
Thank you, Philippe. Tony Hyams asks whether you could explain the makeup of the International Court of Justice and what mechanisms are in place to ensure political neutrality.
So the International Court of Justice in The Hague, as distinct from the International Criminal Court, is a court that is the principal judicial organ of the United Nations, and it has 15 judges. The International Criminal Court, and it has, the ICJ has jurisdiction over disputes between states and to give advisory opinion. The International Criminal Court has 18 judges, also sits in The Hague, and is created by a separate treaty, the Statute of the International Criminal Court. So there are two different courts, and there is no connection at all between them. The judges are different, the powers are different, the jurisdiction is different. In both cases, you want the best possible individuals as judges. And that happens up to a point, but far from totally, because political factors come to play in the election of all international judges, including the European Court of Human Rights, the European Court of Justice, and so on and so forth. And so at any one time, the quality, if one can put it like that, of the judges on these international benches is uneven. Let me be very careful what I say, since I appear before both courts. I'm going to be a little circumspect in what I say exactly. It is, let us say, uneven. But it's uneven. Its unevenness is the responsibility of states, who often adopt criteria other than the quality and excellence of a candidate, and take refuge in political considerations in voting in certain characters on these courts. So that is, I think, an issue. The legitimacy of our international courts and tribunals depends upon the quality of our judges, and that is a matter that I think needs to have continuing close attention.
Henry Mail asks whether you could comment on the tension between the need to prosecute alleged criminals in the interest of justice and the need to offer amnesty in the interests of peace and democracy. And he was thinking of Pinochet, but there must be others. And I would add what is happening in Northern Ireland at the moment, the questions that are being raised there about the prosecution of those involved in the Troubles.
Well, that's another very, very good question, David. And it's a global issue, actually. I mean, you know of many of examples. There is, of course, Pinochet, there's South Africa, there's Rwanda, Yugoslavia, but of course we have Northern Ireland. And we have a desire now by the British government to somehow bring to an end certain investigations and prosecutions. The position under international law is very simple. If you have committed an international crime, so you recall war crimes, crimes against humanity, genocide, crime of aggression, there is no limit in time. You are potentially exposed forever. That is why, for example, those of you who've read The Rat Line will know, I found myself in the extraordinary situation of meeting with a 95-year-old German former member of the Waffen-SS who had given harbour and security to Otto Wächter while he was on the run. And the condition of that interview that I had with him back in 2017 was that I not ask any questions about what happened before 9th of May 1945. Why? Because the individual concerned, Burkhard Hartmann, was every day worried that he'd feel the tap on the shoulder. So there is no statute of limitations for international crimes. And for domestic crimes, it's a different issue. There are limits depending on the gravity of the crime. Now, this is a really big question. If a community has been engulfed in conflict, the criminal law is one of the instruments that is available to you to sort things out. And my own feeling is that in certain circumstances, it is right to consider other mechanisms to help a community recover from its difficulties. South Africa, as you know, had a remarkable truth and reconciliation process. And the deal basically was that if you submitted yourself to truth and reconciliation and did so honestly and openly and fully, you could exclude the application of the criminal law to you in relation to certain crimes you may have committed during the period of apartheid. And I think that system worked really well. And in other places, it has worked less well. And I am very open to a community making a determination that it's willing to give truth and reconciliation a go as a way for a community to heal its wounds. The big difficulty arises, what if international crimes are committed and the country in which they have been committed decides it is going to engage in a process of truth and reconciliation, but the international justice system doesn't recognize that process as meeting minimum standards or indeed as being effective at all? What takes precedence? And that is really the next stage of these important debates on the application of the rule of law. The International Criminal Court has a principle of complementarity. But basically, the ICC won't get involved in investigating or prosecuting international crimes until it is satisfied that justice cannot be done at the domestic level. But there is a gap in the ICC statute. And that gap is truth and reconciliation type processes, because the ICC statute is premised on prosecutions taking place at the domestic level, not truth and reconciliation. So I think we need to have a lot more thought about these truth and reconciliation processes. But speaking for myself, I think if they are done properly, one could imagine that they could be utilized. Against that is what is happening in Colombia right now. Colombia is a country which, as you know, has had an intense internal conflict, partly fueled by drugs-related activity. And it has eventually come to a peace settlement in which it has opted for amnesties based on truth and reconciliation, but that has not achieved majority support in Colombia. And I know this in a very personal way because one of my legal assistants is a Colombian who was himself kidnapped and abused during that terrible conflict. And he has explained to me at length why he is against the amnesty and the truth and reconciliation process. He is firmly of the view that the only way justice can be done and the harm to which he was subjected and to which his community was subjected healed is a criminal justice system. And it's very difficult when you're faced with someone who has been through what that person has gone through, for someone like me to say, yes, well, but theoretically you could have truth and reconciliation and there could be amnesties in certain situations. So this is a really complex issue, and I have come to learn, as you will have appreciated from my writings and generally my engagement with these issues, I try to avoid always reaching firm conclusions or suggesting that things are black and white and it's yes or no or this should happen. One learns to listen very, very carefully, and one learns to listen with particular care to victims of terrible crimes, domestic and international, because their views may not be always dispositive, but they are darn important. So this is a really important and complex question, which does not admit of an easy answer.
Thank you. Now, Tammy Ambrose asked what body is charged with enforcing the judgments of the International Court of Justice?
Well, I'm sorry to say it's the Security Council of the United Nations. As many of you know, 15 members sit on the Security Council, 10 of the members are revolving and 5 are permanent members. And those 5 permanent members each have a thing available to them called a veto, which means they can block a decision, which means that when you get to a situation in which one of the 5 permanent members has a big interest in an issue, that country will exercise a veto and stop action from being taken, either to give effect to an ICJ decision or, for example, in relation to Syria, to open a criminal investigation under international law for the crimes that have very obviously been perpetrated in that territory. Russia and China have blocked that from happening, just as the US has blocked certain things from happening in relation to Israel and other parts of the world. So the Security Council mechanism created in 1945 is plainly a problem. It needs revising, but it's not going to be revised in the foreseeable future because it's based on a treaty and you need the support of all participants in that treaty, including the permanent members. I just say very clearly, the idea that in 2021, Britain and France are permanent members of the Security Council is an absurdity. That reflected the world as it was in 1945, and it's a nonsense, and it delegitimizes the entire UN body to have that situation, but it is the political and legal reality. I think the solution will not be so much as to remove France and the United Kingdom, but to add new permanent members and to give them analogous powers, or to remove the veto completely, which is what I'd be in favour of, or at least having some mechanism of a group of countries coming together and exercising a veto, but not one single country. But that view is not yet a dominant view, certainly in the 5 permanent members, and so that is unlikely to happen. So we have a real structural problem there in the delivery of international justice.
Thank you. I'm afraid I can't take any questions from the floor by way of a raised hand, but if you want to put questions to Philippe, would you go through the chat box, please? From Andrew Mitchell, is there any evidence of a change in approach to the international courts on the part of the Biden administration?
Well, it's a mixed bag, the Biden administration. I mean, they removed the sanctions from the International Criminal Court, and that is a very good thing. On the other hand, they are not respecting the decision of the International Court of Justice on Chagos in 2019. Only 4 countries in the world are now supporting the United Kingdom on the Chagos issue, which of course concerns the return of 2,000 human beings to the homes from which they were illegally, forcibly removed nearly 50 years ago. And those 4 countries supporting the United Kingdom are the United States, Australia, Israel, and Hungary. And that coalition speaks, I think, very loudly. But no one else supports them. The rest of the world is in favor of the International Court of Justice decision on Chagos being taken forward. I don't think it's probably quite as lopsided in relation to the advisory opinion of 2004 on the war that I talked about, but it's pretty lopsided. So I'm afraid the Biden administration may be a lot better than the Trump administration, but it is still some ways off, I would say, a genuine commitment to the idea of the rule of law in international relations.
Tamar Ambrose wants to know if there is any appeal process from decisions of the International Court of Justice. The rest of her question has already been answered by you, Philippe. But
there is not. Its decisions of the International Court of Justice are final, and there is no appeal process.
So James Hooper says, and I think this goes back to something you've already addressed, but I'll put his question to you anyway. Has the change in regime in the US made any difference to the Trump sanctions referred to?
Yes, it has. They've gone. They've been removed. I give credit to the Biden administration. They have been removed, and they were removed pretty early on. So the Biden administration has reconnected. It hasn't ratified, and it's not going to ratify the ICC statute, but it has, if you like, moved to a more positive position in relation to the International Criminal Court.
Anthony Wenson has sent something, and I'm having difficulty reading it, but basically what he says is, Professor Sands has addressed a number of extremely sensitive political situations. Are some situations so fraught, so political, so hot, that pushing for recourse to the law and to the court proceedings can be really counterproductive? Rather, the reconciliation may be better served by the diplomatic realm.
Well, I mean, I don't know, whether they're counterproductive, but we do know, for example, that the development of international criminal law, and it's a big question and there are lots of ways of addressing it, but the development of international criminal law has unintended consequences. So when an individual is indicted, and usually the indictment is secret, for international crime, if that person is a head of state, the fact that they're likely to be subject to an arrest warrant when they leave office is a tremendous inducement to hang on permanently. And that is one of the unintended consequences. Every act has unintended consequences. And so one of the questions that often arises when a prosecutor is faced with an issue, do I indict this person now? Do I wait until they're out of office? Do I make it public? What do I do? These are incredibly delicate matters. And I think that answer is applicable more broadly in relation to other kinds of situations. Of course, one cannot exclude the possibility that an embrace of the rule of law in certain situations could actually make things worse. But in general, I would say going with the rule of law is the right way to go.
Thank you, Philippe. One of the problems of being the chair of a meeting such as this is that sometimes I have to do disagreeable things. And one of the disagreeable things I'm doing now is to call an end to the questions. There are more, but I see we've really gone over time, and to some extent, there are still other things that need to be done during the course of this meeting. So I will say thank you, Philippe, but I will ask John Bowers to make a formal vote of thanks to Philippe on behalf of this organisation. Is John there?
Yes, thank you very much. It should come as no surprise that this is the largest audience for a Rueff lecture. Many of us know for over many years Philippe as a spellbinding speaker with a very wide range of interests and coverage, as is clearly shown tonight. We want to thank him on behalf of the Lawyers Group, and I'd also like to thank all who have been involved in putting this on. I also think how proud Philippe Rueff would have been with this particular lecture. I think it's appropriate to say next year in London in person. Thank you to everyone for joining, and I hope that we can be in person next year. But thank you very much to Philippe Sands.
Thank you, John. And now, most importantly, I'm going to ask Lawrence Barras to appeal to your generosity for donations. I should tell you that we already have received donations totaling £3,000 and sponsorship of £1,500 arising solely from this event. And I have asked for a direct link to the donations page of our website to appear in the chat box. So Lawrence.
Thank you very much, David. I hope I can be heard. I'm very reluctant to add a melancholy note to the proceedings after such a superb and inspiring talk by Philippe, to which I'd add my own appreciation. But I want to refer back, if I may, to the night of the 31st of August last year, when tragedy struck our beloved village in Israel. The School of Peace, about which you saw details in the introductory film, was engulfed in a fire. The contents of the unique library were burnt and much of the furniture was destroyed, but thanks to the efforts of the villagers The building itself was saved, as you'll see from a picture, which I hope somebody is going to put up on the screen, but it's not happening, so I will move on. It wasn't the end of the story. A mere week later, on the 6th of September, the perpetrators of this evil act returned to the village under cover of darkness, and they finished the job they'd begun the previous week. This time, they made no mistake, and the whole of the building was reduced to ashes. And there is another photo of the fire on that dreadful night. I don't know whether, Mark, you can put that up on the screen, but don't worry about it if you can't. There's no doubt whatever that this was an act of arson by a group who found the inspiring ideas that peace is possible through supporting oh, there it is, there's a picture of the fire. That was our wonderful School of Peace, and that was in September of last year. There's no doubt that that was an act of arson by a group who found the inspiring ideas that peace is possible through supporting education, dialogue, promotion of understanding, and anathema to their warped minds. And it won't surprise you, I suspect, to know that the arsonists have never been apprehended. Indeed, this wasn't the first such attack on the village. 3 years ago, the wonderful primary school was vandalized, and the specialist books, which I've seen myself, which are used to teach Arabic to Jews and Hebrew to Arabs, were deliberately torn apart, and vile and racist messages were left painted on the walls to greet the children when they came to school the following morning. The School for Peace at Never Shalom, Wahat al-Salam, is absolutely an amazing institution. I know it personally, I know several of the key figures there, and I promise you they are not the types to be deterred by threats or deflected from their work by these evil attacks. The School for Peace performs a very unique role. We heard a little bit about it at the beginning this evening. It works with young Jewish and Palestinian groups through special programs to develop awareness of the conflict and to take responsibility to ameliorate relations between Jews and Palestinians. Since its establishment in 1979, over 70,000 youngsters have attended courses at the School for Peace, and many of them have remained committed to effecting positive change to which they devote the rest of their lives. Over 1,000 individuals who took part in School for Peace courses for group facilitators have gone on to work or run peace and human rights organizations, not just in Israel-Palestine, but right across the globe. So we're not just talking about Israelis, ladies and gentlemen, but many graduates from other nations also. The influence of these graduates, therefore, is never ending. They don't just get trained and vanish. They actually continue to spread the message they learned in our village. Oasis of Peace UK has a long and very proud history of support, not just for the village primary school, but also for the School of Peace, which I've been describing. These past 12 months in particular, along with our sister organizations around the world, we've been raising funds to help rebuild the School for Peace and restock its iconic collection of books. I'm delighted to say the construction's already begun of what we hope will be an even bigger and better building. So I'm asking you tonight to help our efforts in any way you can. There's a reference in the chat link, as David told you, to how you can support us tonight. And at the end of this meeting, there's an email connection which we'll bring up on screen. You know, we mustn't let the evil racists have the last word. I'm reminded of the words of the German playwright Heinrich Heine, who wrote in his play Alamasor, wherever they burn books, in the end, they will burn human beings too. And if you share the belief personified in Never Shalom Wahat al-Salam, that ideals of coexistence and equality are the only way forward, I ask you please to help us realize those ideals by supporting us tonight with a donation. Thank you very much indeed.
Well, ladies and gentlemen, that brings this most enjoyable and rewarding evening to an end. And I must thank you all for attending, and I must also thank our technician, Mark Jacobs, for doing whatever he had to do to keep the show on the road. And I must also thank Lorraine Singer for assisting me, doing much more than simply holding my hand. Don't switch off yet, please. There follows a charming short message from some of the villagers' children. Look at the chat box if you want to know what they're saying. Other than that, good evening, everyone, and thank you.
في لحن مجنون ما في أحسان